We have read the briefs and we're prepared to hear the argument. Each party will have 15 minutes to present. The appellant proceeds first and may reserve up to 5 minutes for rebuttal. If you wish to reserve any time for rebuttal, please let me know as I'll be keeping time.
Thank you, Your Honor.
We're ready to proceed.
Thank you, Your Honor. Good morning, Your Honor, other justices. My name is Steve McGowan. It's my first time in your court arguing an appeal. So hopefully I'll be consistent with the other lawyers that appear. You haven't read my brief, and I just reread it again this morning. And of course, the lady that helped me write it did a fine job of translating my recollections. Maybe I could go backwards on this one a little bit. There seems to be quite a bit on the state's case about the instruction and the ALS appeal and things of that nature that I did not object to the instruction, the final instruction on the refusal. Well, I made my objections that there should not have been an instruction on the refusal made to the jury because it wasn't done properly. I had a pretrial motion on that, which I think case law is pretty obvious that the state, where they used the wrong form, they have to do something consistent with showing why the court could rule that it still was adequate warning to an arrestee. They didn't do that. I asked for reconsideration. Upon reconsideration, that was also overruled by the judge. So what happened?
So we're talking about, what was the nature of your pretrial motion?
I was appealing the ALS, the administrative license suspension initially given to my client. Okay. For a number of reasons. Well, I was caught unawares in that they didn't bother to call in. Of course, my colleague wasn't there, so I'm not criticizing the other attorneys. Evidently, that's what they do. They didn't call in the arresting officer. So what happened in that case was, from the trial record, from the transcript, they were out in some plaza. He didn't take them before the machine. He didn't observe them for the 20 minutes. He didn't calibrate the machine and give them an opportunity to take the test at that time, which follows the Department of Health regulations. All right. And as this court is well aware, people refuse, they get in the police station, and then they sit down there, then they decide to take it. But certain things have to be done, which weren't done in this case. So I believe, that having not conformed with that the ALS we should have been successful in appealing that. Therefore, there wouldn't be an instruction, and it wouldn't be an issue at trial. Having done this for many, many years, I have come to learn that for juries, that is a major factor. And when you get the instruction, sometimes they put too much weight on that rather than the actual facts of the case.
So just so that I'm clear, your objection was to the fact, and we're speaking factually now, that the 2255 form that is normally read to the individual at the station where the breath test is given was done on another location. Is that correct? As I recall, in a parking lot?
Yes, that's part of it, but it was also the July 10th form instead of the 13th.
Okay.
And Eastlake versus Gomez says that having done so, that the state has an opportunity to rebut or to put on other evidence that would qualify that. If the state doesn't do that, then it's an automatic. Okay. Now, if the officer would have come in same as in trial, he would have come in the pretrial motion, then the questions would have been asked, well, where did you do it? They didn't even have a breathalyzer available. So they couldn't even take him to a station and put in front of it and so on and so forth.
Well, I guess they could have and
not been able to take his test.
Yeah.
Or they could have.
That begs the question of what what difference it makes where the refusal takes place, whether it is at the station or someplace else. I guess that's what I'm getting at.
In order, the case law would indicate, and the formality is, well, first of all, the person's under arrest. He's taken into custody. He's then taken into a room and he's observed for 20 minutes. The machine, whether it's an 8000 or a breathalyzer, is prepared by the operator. Then he's asked a series of questions, and he may have already, while he's waiting, have been read the 2255 form. Then he says, do you want to take the test? And then they put him down as a refusal. If he takes the test and he doesn't give a valid sample, it's put down as a refusal. But what's supposed to be done is not assume what's going to happen at the station, but there's strict liability or strict compliance that's required. Having said that, however, once we got to the trial level, we know that at the trial level, those things were not conducted, and it should not have been a refusal. It wasn't a proper procedure to charge him with a refusal. And having done that, I objected to any instruction on a refusal. So they put me in a catch-22. Having objected to it, and the judge, and out of respect to the judge, said, I'm going to give this instruction. Well, then it's my duty to make sure they give the proper instruction. So I was objecting to the instruction on a refusal, but not that the specific instruction was wrong. That would be disingenuous. I'd say, well, you're given the proper instruction, but you shouldn't be giving it at all. So there is an objection to that. And the state's brief, they put a lot of effort in that, the idea of a plain error, that it's, I didn't raise a plain error. Well, it's obvious that I had an objection to it, but it is absolutely plain error to allow that to go where none of it, not the form, not the procedure, was properly conducted, and that was a major factor in the case. Then moving forward, when you look at the evidence towards the manifest weight, there was a defect in the road. We had photographs of that. There was a crash. The person that said the car was run into the back, and there's evidence in the case, and it's in their footnote, was with an Austrian accent, and it was a fellow we couldn't get there because he was in Austria by the time that we had the trial. We believe he was in Austria, couldn't find him. That he was the one that said to the officer. So that's not disputed. There was testimony that not my client, not the defendant, said he was run into by the back. They hit a defect in the road, the car crashed. He had an head injury. Two of the occupants were bleeding at that time. And he wasn't out of control, and the testimony by the officer, I believe it's Hayes, said, when I questioned him, first of all, he never gave the legal definition, not the definition, but the statement of being under the influence. He said he was drunk. But when questioned on whether he was swearing, out of control, acting differently, nervous, or any of those things, he could not state for the jury that yes, because of the ingestion of an alcoholic beverage, this person's abilities, actions, reactions were changed, and his demeanor had changed, which it wasn't. And I think there's a recent case, maybe shortly after this case, we have an extended video of the defendant sitting in the back of the police cruiser, and it was played for the jury, and even though you're a reviewing court, this court can review this and observe it in the extent that you can make a fresh determination for yourself, because that wasn't a factual determination made by the jury, but it's a review of the evidence in the case. And when you watch this young man, he was in there for a long time, he was just sitting there. He wasn't gibbering, he wasn't talking, he wasn't looking out or acting anything unusual. And his injury on his face was clear, and when Officer Hayes testified, I believe at some point in there, he said he didn't see any injury to his face or his head. All right.
There was some testimony, I thought I read in the brief, that said that the officer had difficulty moving him away from the front of the cruiser, that he was leaning on to the cruiser. Is that this case, or am I getting this?
There is, in the state's brief, they say that on there.
And he stumbled badly when he...
Well, but that was never clarified, even if he did that. When you look at the video, when he's sitting in the car, he looks fine. However, they just had a frontal collision that caused the car to be totaled. And that, that creates a legitimate question of fact there. But when he said that he wanted an attorney, and when he spoke with them, he was very polite. He was able to produce his insurance and his license for them. They stayed on the scene and things of that nature. There is no appropriate testimony by Officer Hayes as to intoxication sufficient as a matter that doesn't create a legitimate question of fact here. There is nothing from which the jury could conclude from that officer's testimony to make the jump that he's intoxicated or under the influence as a technical term in the state of Ohio. Because when you ask the questions, and it's in there, that he admits that he doesn't know how the fellow acts before. There's testimony there, he's not swearing, he's not doing the things customary to drunk drivers. And when you watch the video, when he's sitting in the back of that car, how calm he was and looking and things of that nature.
Let me stop you just for a moment to let you know that you are going into your 5 minutes. If you wish to continue, feel free to.
Just a minute or two.
Yes, go ahead.
Or if you have questions, Your Honor, I would just soon answer
Go ahead.
that. Okay. Well,
You were saying he was sitting there looking calm.
yeah, I'd like you, and you can, I don't know what your procedures are here, but when we have these in the last year or so, the reviewing court can look at those, as you're well aware. And I think that speaks volumes about it. When you consider the jury questions and things of that nature, about whether that he was previously arrested and things of this nature, the reality is the refusal should never, that's plain error, jumps off the page. It was error over our objection to instruct like that. And I believe that based upon, there was a single car accident, there's no absolute proof that my client claimed to get hit from the rear, but an Austrian accent said that. He had a head injury at that time. They waited on the scene. He was able to answer questions. And they did, and the biggest thing also, lastly, is that when the officer released him, he drove him to his house and he released him. He's walking out of the car, and it was a jury question, I believe. He said, how was he walking? And the officer said he was walking fine back to his residence. So he wasn't stumbling or doing anything at that time. So whatever time I have left, I'll take the podium again and primarily just answer your questions, Your Honor.
Very well, thank you.
Good morning, Your Honors. Brian Bremer on behalf of the City of Akron. I just want to start off by addressing a couple of issues that Appellant's counsel said during his oral argument. One of which is who told the officer that there was a second car and that they struck the vehicle. He is referring to testimony from one of the defense witnesses about who said that. The officer was clear that it was actually Appellant that told him that the car had been struck by a second vehicle. The officer investigated that claim. There's only one set of skid marks at the scene. There was no damage to the back bumper. In fact, the only mark on the back bumper was after the officer touched it with his finger and wiped some dust off of it. So the officer really, he investigated the idea that there could have been a second car. There wasn't a second car. And that had been Appellant's story at the scene of the accident. At trial, the Appellant did testify that he'd hit a pothole, and that leads to the second point. He brings up this picture of the scene. Well, the officer said that wasn't the scene of the accident. The officer denied that when they were shown this picture, he said that is not where the accident occurred. And so it's a credibility determination as to whether or not that picture actually refers to the scene of the accident. And that was a question for the jury, as is most of the first assignment of error issues. The officer testified that when he came to the scene of the accident, he saw 3 individuals standing outside of a car that had crashed into a cement barrier. They all seemed to be very intoxicated. When he asked who was driving, to the 2 people pointed at Appellant, Mr. Foos. And Mr. Foos sheepishly admitted, that's the officer's words, that he'd been the one driving the vehicle. Mr. Foos had a strong odor of alcohol about him. He was slurring his words. He was leaning against the cruiser to try to steady himself when he was speaking with the officer. He told the officer there had been a second car, which the physical evidence does not support that version of events. And ultimately, he ended up refusing to take the breathalyzer, which all that put together definitely supports the conclusion that he was intoxicated when he crashed that car. And the officer testified to all of that. Whether the jury decided to believe the officer or not is up to the jury as the trier of fact. And
Did
there's
the
nothing.
officer testify based on his training, education, and experience that the appellant was under the influence of alcohol?
He did not say that. He just said that the person was intoxicated, which is something that we would know in their common knowledge. Whether someone's intoxicated to the point of not being able to control their vehicle, and also the actual crash in the vehicle in a single car accident is also indicative that you're not able to control the vehicle due to your intoxication level. Turning to the second assignment of error, as far as the jury instruction goes, he did, as I put in my brief, he did object to the instruction being given initially, but when the jury instructions came in, the judge specifically asked, does anyone have any objections to these instructions? And on page 114 of the transcript, appellant's counsel says, no, I don't have any objections to these. So the state's position is that he has waived, that he forfeited the objection at that point because he did not renew it. There's case law to that effect out of this district. I cited in my brief. But even assuming that we're not going to say that he forfeited all for plain error, there was no error here. The truth is there's testimony that appellant refused to take a breathalyzer. That is all that mommy versus anistic required, was the idea that you have refused to take the breathalyzer. This is a pretty consistent rule across the state. I cite a number of cases in my brief about this. The 10th district says that once you refuse, you don't have to be given a second opportunity to take the test after the fact. But that was in Monnier, which is from, I believe, 2013. There's a case out of the 4th district about the idea that even offering the test after the period in time where it would have been admissible, it's still appropriate to issue the refusal instruction if they refuse under those circumstances. And the idea is that it's the refusal itself, is the act of refusing is the indicia of guilt and of knowing that you're too intoxicated to pass that test. And that's why that instruction is permitted regardless of whether or not the test would have been admissible at the trial. And that's been consistently applied across the state of Ohio in the years since mommy issued the instruction itself.
So what are we to do with the fact that he could not have been tested in any event?
Well, he didn't know that. That could not have possibly informed his decision-making process. So again, it goes to the fact he didn't think he was going to pass that test, so he refused. Or at least that's an inference you could draw from his refusal. And so the fact that he couldn't have been given the breathalyzer at that time is irrelevant to whether or not he thought what his consciousness of guilt would have been. So that's why that instruction was appropriate, even assuming that they couldn't have given him a test in some manner, whether they had to drive him to another area to give him the test or take other actions, because the police officers have taken other actions to give breathalyzer tests, even with the one at the station not working. So that's the reality of that instruction, was that it was appropriate under the circumstances. Because there's no dispute that he refused the test. And this idea that the officers didn't comply with all the requirements necessary to administer the test, he doesn't cite any cases in his brief to support the conclusion that the instruction is inappropriate under those circumstances. The only case he cites to support his second assignment of error is a case that doesn't have to do with jury instructions. It doesn't have to do with refusal. It has to do with whether or not the evidence would have been admissible. So the authority in the state is the instruction was proper, therefore there was no error, and he has not cited any authority to the contrary on that point.
So assume for a minute that he wins his ALS appeal. Under these circumstances, that he ended up winning the ALS appeal, would the state still be permitted to have the refusal instruction in the trial?
If he won the ALS appeal, that would possibly be indicative that he had not actually refused the test, I believe.
Right, well,
Yeah.
in this case, we have a situation where we have an outdated form. So for whatever reason, he wins his ALS appeal. And there's no finding on refusing based on it's indicative of guilt, because there doesn't need to be. I'm just asking if the state then gets to use the same jury instruction after if he had won his ALS appeal.
I think you would actually, because it's still the fact that the ALS appeals whether or not you automatically have to lose your driving privileges. It doesn't go to whether or not you, the instruction is more about the consciousness and what you can infer from someone refusing to take a test that would show whether or not they're actually intoxicated. And that's what the instruction is about, where the ALS is a much more technical proceeding about whether or not you automatically lose your right to drive. And that requires more.
Is that inference kind of wrapped up in, look, not just, I'm not gonna take the test because I can't pass it, but I'm gonna choose not to take the test and face the license suspension. Let's assume that wasn't a threat. I mean, is the inference wrapped up with what the consequence of refusal is, or just the act of refusal?
It's just the act of refusal. And to the point about the ALS suspension, the ALS itself, like I said in my brief, that issue is not actually before this court because it was not timely appealed, and so therefore it's not something that we should really be talking about. Having said that, there's no evidence that that 2010 form did not contain the statutory language that you need to read to someone in order to invoke the automatic license suspension. There's no indication that the language was different from what from what the revised code requires to be read before the ALS can be imposed. And he has not cited any case law that the idea that this actual language being the same, basically he can't prove prejudice on this issue because that form, from what I can tell, based on what's in that video, tracks the revised code as it stood at the time of his arrest. So even assuming everything else, the ALS was appropriate under the circumstances because the form gave him the language that was required under the revised code in order to impose the ALS suspension.
So there was no request to take judicial notice of the difference in the forms?
There's no evidence in the record that the forms are actually different. There's a revised form. I mean, but the forms can be updated to add additional information that's separate and apart from the actual implied consent language, such as the new form doesn't put the social security number out for some reason. The old form had a misspelling of when you say name, first name is misspelled with no I. I don't know what the difference is, and it's not on the record. But what is in the record is what is read to him in the backseat of that cruiser, and that language appears to track the revised code. So even if this was before the court, the ALS was still appropriate under the circumstances because he received the implied consent warning that he was supposed to receive. And if there are no further questions, I will sit down.
Thank you.
Thank you.
Counsel, you have 3 minutes remaining.
Thank you, Your Honor. With no disrespect to my colleague, he's absolutely wrong. If you win the ALS appeal, you can't even mention it during the trial. Can't even mention it. It's out. It's not even a consideration. And in this particular case, now even a refusal, if you have a prior, can be a criminal charge. Under Gustafson, 35 years ago, they said you could have double jeopardy because it was a civil in nature. So to say that I have to appeal a pretrial motion when there's still a trial being conducted is nonsense. But during the trial, when the officer came in, the judge had the opportunity at that time to see that none of it was complied with. The procedures, strict procedures, in order to get a refusal, it's administrative. It has to be strictly complied with. It wasn't a criminal aspect of it, but once you're in the criminal trial, if you don't do it right, then you can get an instruction on that. Just like you could get an arrest if the attorney doesn't raise the issue that the field sobriety tests weren't done right, if he misses that, but you go to trial and you cross-examine on it, you could get an appropriate instruction on that. This is a fluid thing, it's still going on. You can't mention it, it should have been granted, and the idea that he's saying, or anybody else says, it's the same language, and that we didn't prove it wasn't the same language, that's not what Comas says. That's not what our law in the United States is. They have to prove that they did it correctly. We don't have to prove that they did it incorrectly. We raised the issue. You got the wrong form. If they would have brought the officer in, not only do you have the wrong form, you didn't take him before the machine, you didn't take him back to the station, you didn't observe him for the 20 minutes, make that statement, and then ask him to take the test. And then the operator puts it down that he refused to do that. None of it was complied with, so when that comes into trial, then even though they could start to do that, they could bring it in because I lost the pretrial motion. Once that's in there, then I should have gotten instruction. That you've heard evidence on that, but it wasn't done right, and therefore you're not to consider it. Once the judge makes the ruling, what am I supposed to do? Be held in contempt of court? Say, Judge, you're wrong, and act a fool? That's not what we're supposed to do as attorneys. We're supposed to have some decorum. So the judge makes that
decorum is one thing, and asking for a sidebar so that you can
Well,
preserve the record is another.
we had sidebars, I understand, but I did object to that repeatedly, and they're saying, because the judge said, well, this is the standard instruction that's given in all these cases when there's a refusal. Am I supposed to object to that? That's the proper instruction. My objection is, it shouldn't have been given, there should have been a curative instruction to disregard it, and the officer didn't do it the right way. All right. I forget what else he said. Anyway, it doesn't come in under those circumstances. And this one shouldn't have come in.
And you have reached the end of your time.
Okay. Thanks. It was a pleasant experience, I may say. I don't know if the outcome, I'll be pleased with it, but I was very pleased with the outcome. And I thank you, Your Honors. Thank you very much.
Thank